Hi there and welcome once again to Employment Hour in 30. I'm John Scholes. He is Lior Samfiru, here to answer all of your questions when it comes to your workplace rights and the job where you spend, well, it's probably where you spend most of your life, right? 8 hours a day, 5 days a week for a lot of people, so that's like 80,000 hours a year. It's incredible. You got to know what's happening when it comes to your employment laws. That's why we educate you here every week on the show. 1-855-821-5900 to reach out anytime, or help@employmentlawyer.ca. A lot of stuff to get through again on the show today, Lior, as we always have. You're looking fantastic, my friend. You're looking really good.
I have to keep up with you, John.
You know,
yeah.
Let's go. I'm training him. He's learning. It's good. A lot of stuff to get through on the show today. We're going to talk about the severance pay calculator in a later segment. But first, as always, we get into the week that was, something that's been happening on your desk. It would be of interest to all of us, really.
Absolutely. And it's great to be back here. And every time I'm here, people call me after and say, you know, I appreciate you being here. I appreciate you providing that information. It's valuable information. And I'm so happy to hear that. You know, it is really why we're here, because we're talking about relevant things. We're talking about your job, your workplace, your rights. Everyone should know their rights. You know, I live by the motto, you have a right to know your rights. So if you know your rights, you're armed, you're powerful, you know what to do. So if you have any questions about your workplace rights, stay tuned. We'll cover so many topics on this show and on every show. And of course, if you want to talk about your specific matter, don't hesitate. Reach out to me, call me, email me. We'll give you that contact information throughout the show today. There's no bad questions. There's only answers and solutions. And to get us started, as you said, let me talk about a situation that came across my desk just a couple of days ago. This has to do with probationary periods and probationary employees, and this idea that probation is not automatic. So I spoke with a gentleman who had worked for a company for just shy of 3 months, and he was in a marketing position, a senior position, and short of 3 months, maybe a week short of 3 months, the company says to him, you know, unfortunately, it's not working out. We need to make a change. It's not the right fit.
Not a good fit.
It's not a good fit. And I asked them, well, did they offer you any payment? They said, well, we don't owe you anything because it's been less than three months, but we're going to be nice. We're going to offer you 1 week's pay. And he wanted to call me. He did call me. He wanted to know what is he actually owed. First of all, he didn't disagree, John, that it probably wasn't a good fit. We're not blaming the company for making that decision. It simply came down to compensation, to severance. Do they owe him severance? He worked there for less than 3 months. His employment agreement did not say anything about probation, and the company assumed that just because he's been there for less than 3 months, he's automatically on probation. Nonsense. I've said this to you before, I've said this on the show, but it's important to remember that probation is not automatic. The only time you're on probation is if you sign an employment agreement that specifically says so. Otherwise, on day one, you're not on probation. So what does this mean for him? He was let go and he's owed severance. For him, he was owed about 3 to 4 months' pay.
Wow.
Now, remember, short service employee, less than 3 months of employment, still gets 3 to 4 months of severance. So not 1 week's pay, not even 1 month's pay, 3 to 4 months. So there's two lessons here. Number one, that probation is not automatic. And if you're let go, even in the first 3 months, you are owed severance. The second lesson, of course, is that even short service employees get substantial severance. You work for a month, for 3 months, for 6 months, for 2 years, you get good severance. Sometimes it could be a few months per year. I've had many people that have worked for a few months and they're owed a few months severance. Right. So remember, probation is not automatic and you're owed severance.
Does it have to be in writing or verbal?
No, it has to be in writing. Probation. Yeah. Probationary period has to be created in the employment agreement. And it's not enough for a company to have some sort of a policy, even a document, a manual that says you're on probation for 3 months. It has to be a document that you, the employee, signed before you started working. If you signed a document like that you're on probation, that may impact your termination entitlements. If you did not sign a document that says specifically you're on probation, you're not on probation, and that's important when you lose that job because then you get your full severance.
Can a company go beyond 3 months, or is 3 months the max for a probation period?
A company is not allowed to have a term that says longer than 3 months we can let you go without compensation. So practically speaking, a probationary period can and should not last more than 3 months.
Right. 1-855-821-5900 is the number. You want to go to employmenthourtv.ca. That is a great resource for all things about the show, contact as well, and a place to find where you can catch our radio show, which we are into year 7. Hard to believe we've been doing it that long and loving every minute of it. Get a ton of calls on the show. We play some back on this show, and I know you want to talk about it, so we'll get to our first call of the day.
I got terminated 15 months ago. Gave me the standard 2 weeks for every year. So I got, my 5 years worth. That is, 10 weeks. But, and I rolled on that anyway. So it's quite an intimidating thing. So you have a tendency to cringe when it happens. Should it not have actually been based on my typical 60-hour week and not my 44-hour legal week?
I remember that phone call.
I remember that as well. So there's an incorrect assumption that's underlying this call, and that is that, it's standard to get 2 weeks per year. So he essentially saying, yeah, I'm fine with the 10 weeks. I just want to know if they calculated it correctly. Well, let's start with the big problem with this call, and that is that 10 weeks is completely inappropriate. He's owed a lot more. Remember, age, position, length of employment are the factors, and it's not a week per year. It's not 2 weeks per year. It is a lot more. We'll talk in a second about what this guy is actually owed. A lot more than 10 weeks. His question, though, is that they have to calculate it on the basis of the 60 hours I actually work or something else. Right. Of course it's the hours you work. If you work 50, 60 hours a week, whatever income you earn in that week, that's what's going to be used to calculate your severance, including any overtime that you usually earn. So it's not just based on 40 hours or 44. If you work 60 hours and you get $2,000 a month in overtime, whatever it is, that has to be calculated as part of your severance. Anything else is a wrongful dismissal. But now let's go back to figure out how much he is actually owed. So rather than me just tell you, easy for me to do, let's actually plug that into the severancepaycalculator.com website. So let's see how much he's owed. So he's in I picked, let's say, a technical role. He's been there for 5 years. I made some guesses on the other factors, and he was offered 10 weeks pay. Yep. Well, guess what, John? Severance calculator correctly assesses him as being owed right around 8 months pay. Now, 8 months is somewhere around 34 weeks or so. So instead of 10 weeks, it's 34 weeks. That's 3.5 times what he was offered. That's the problem here. That's a very common situation. We get calls like that. I get calls like that all the time. People assuming that their severance is fair. It's not fair. That's why you go to severancepaycalculator.com. That's where you call me, because for him, this could be a difference of tens of thousands of dollars, John.
I mean, we don't know how old he was. He didn't sound like he was 20. I mean, this could carry him over, has to carry him over till he hopefully finds a new job. And the older you get, the tougher it gets. So you need to maximize how much you're going to get, right? 3.5 times. It's a lot of money.
So, if you make, $5,000 a month, $60,000 a year, the difference here could be, $30,000. I mean, that's a big, big, big difference. Yeah. So don't let that happen to you. One of my worst things that I hate about my job is when I get calls from people that have already accepted their severance offer, and I have to tell them, you lost out on $30, $40, $50, $100,000, and I can't help you. So please don't let that happen to you.
EmploymentHourTV.ca is a resource to find that radio show again. That's where we're getting the calls from that radio show. We'll get to call number 2 now.
I was just wondering, if you have an employment contract that stipulates how much severance you get, should you get terminated, can you fight that? Is it better not to sign a contract when you first start a job?
Excellent. I love that question, and we've talked about this before, and we'll continue talking about it because it's important. Employment contracts, employment agreements. So again, if I'm talking about it from the perspective of the employee, you are better off not having signed a contract. I'll say it again. You are better off as an employee not having signed an employment agreement. You are much better off starting on a handshake or with an email or with a 1-paragraph type of a document. That's much, much better than having a 10-page document, because in that 10-page document, there are going to be a lot of things that are going to be unfavorable to you that would take away entitlements that you would otherwise have. So for an employee, better not to have an employment agreement. Now, she is asking about termination clause. So some employers stipulate in the employment agreement what they would have to pay you down the road if they let you go. Right. That's usually very bad news for the employee. What that tries to do is to limit your future severance. So her question is, can I get around that? The good news is, in maybe 80% of cases, we're able to find ways to get around the termination clause. There are reasons, which I'm not going to get into, it could get fairly technical, as to how and why you can get around the termination clause. So don't ever assume that just because you signed a termination clause, it's going to be enforceable. It's going to limit your entitlements. Because you've been let go, if you have an employment agreement that you believe is limiting your entitlements, I want to see it. Call me. Don't sign anything before I've seen it. But still, the best advice I can ever give is try to avoid signing an employment agreement that limits your entitlements.
Again, to reach out, 1-855-821-5900. It's funny, you tell someone, no, you don't want this. you want this. It's so counterintuitive of what they would think.
Yeah.
Because everything else in life, they want documentation.
Yeah.
They want a rock-solid contract.
That's the idea. You know, it says all these things. It must be good for me.
Right.
No, the law protects you. But the law also says that you are allowed to give away those protections. And that's what an employment agreement often does. It takes the protections that the law provides and either eliminates them or it turns around and gives it back to the employer. So because of that, this is contrary to what most of us believe. Less is more when it comes to an employment agreement.
Our top 5 list for this show this week is top 5 employment law issues of 2019. How about that? I'm surprised I didn't say 18, even though it was written here. So these are going to be pretty important, right?
Yes. You know, there's in the new year, a lot of interesting things come up, a lot of stories, things that I've already noticed happening. So we want to talk about things that people need to be mindful of in the new year.
First one, misclassification of employees as independent contractors. We've done this ad nauseum, but it's worth mentioning again.
It is worth mentioning. And I see this more and more and more, and this is going to continue being a huge issue in 2019. John, people being misclassified as independent contractors when they're not, when they're really employees. So again, without getting into too much detail, we've talked about this before on the show. If you're actually an employee, you can't be called an independent contractor, and this happens very often. If you work for a company, you have a regular job, you go, you come home, and you do the same thing the next day, you are an employee. It doesn't matter how you pay your taxes. It doesn't matter what the company called you. It doesn't matter what you signed. And because you're an employee, you have the rights of an employee. This has been a big issue. Even our government here in Ontario has recognized this as an issue and has made some amendments to the Employment Standards Act to recognize that people are misclassified. So if you're supposedly working as an independent contractor, certainly if you only work for one company, you are an employee of that company. That means you have rights to overtime, vacation pay, etc. And it also means, most importantly, that you have the right to severance when you're let go.
Now, this is bad for both the employer and the employee, even if you just concentrate on the tax pitfalls of it, right?
There's repercussions to misclassifying because our friends at CRA may say, well, wait a second, you really were an employee. So there's going to be fines, penalties for both employer and employee. Right. So it makes sense for everyone to get it right.
Top 5 employment law issues of 2019. Number 2, sexual harassment in the workplace. We hope that this is the year that this finally takes a steep decline.
It is, but it's going to take some work to get there. We've, 2018 was the year of the Me Too movement. But what that did, John, is it brought this issue of harassment to the forefront. It put kind of the spotlight on it. And people now are not afraid to say, hey, I'm being mistreated, I'm being harassed. That's wrong. And that's what we want to talk about, and that's what we want people to be mindful of. Sexual harassment in the workplace has no place, has no business to be there in the workplace. You have a right, male or female, young or old, to be working in an environment that's free of harassment, sexual or otherwise, in a supportive environment, in an environment that's not poison. And where that environment becomes poison, where you're subject to harassment, that is illegal. The law doesn't have any sense of humor when it comes to these things. The law is going to come down very hard on the employer, on the one that's that's harassing you. So if you're being harassed, I want you to try to deal with that internally. Give an opportunity to the company to try to fix it. Talk to the HR person, talk to the owner of the company, let them know, give them that opportunity. If you can't do that, or if you've tried and nothing's happened, I want you to reach out to me. The law now has adapted to realize that people are victims of harassment, and there has to be good remedies under our human rights legislation, under our common law, under the Employment Standards Act. There's all kinds of remedies, so no longer should you be the victim of harassment. If that ever happens to you, there's a lot of options.
Number 3, top 5 employment issues of 2019. This one we should have done April 20th on 420, but hey, marijuana and drug policies for employees, right?
Obviously, marijuana is now legal, and employers and employees have to adapt. Employers should have policies outlining what the expectation is of employees. Are you allowed to smoke in the workplace? Are you allowed to smoke before you come into work, depending on how important a job or how safety sensitive the job is? For most employers, I would say to them, you have the same policies with marijuana as you do with alcohol. If you don't allow people to drink and work, don't allow them to smoke marijuana. It works as simple as that. And we're going to see many cases going to court where people get terminated supposedly because of these situations. There's issues with respect to addiction. So it's something to keep an eye out in the new year.
Top 5 employment law issues of 2019. Get to number 4 now, severance packages for layoffs.
Well, this is for 2019, for 18, 17, 20, and any other year. This is always going to be an important issue. Severance packages, layoffs, temporary or permanent. they are not adequate, okay? In almost every situation, in over 90% of cases, you're staring that severance letter, that severance package is going to be pennies on the dollar. If you're lucky, it's going to be 30 pennies on the dollar. Yeah. If you're not lucky, it could be 3. So don't let that happen to you now that you know. Keep an eye out on that. Go to severancepaycalculator.com. Call me, email me, call someone else if you don't want to talk to me. That's okay. But you have to deal with it. This is going to continue to be an issue. Severance packages are not going to improve this year. So it's your job as the employee to stay on top of that and make sure you get everything that you're owed.
Number 5 on the list, it is the top 5 employment law issues of 2019. We'll wrap it up with this one, and that is accommodating employees with disabilities. Continues to be a problem.
It continues to be a problem, and we also have an aging workforce, okay? And so that means that we may have, an employer may have people with medical conditions, disabilities, things that the employer needs to provide accommodation for. So just a reminder, that's going to continue to be an issue, and the employer has a very strict duty to accommodate. If you need modified duties, modified hours, you need the flexibility of work from home, you need flexibility not to lift heavy objects, your employer has to accommodate. As long as you have something from a doctor that corroborates what you need, young or old, male or female, works just the same. Your employer has to comply. If they don't, that could be a human rights violation. That could be a constructive dismissal. That's going to continue, John, being a huge issue in 2019.
We'll get to some details on the severance pay calculator and what to do when your hours take a hit at the workplace. That's all coming up. 1-855-821-5900 and employmenthourtv.ca. Lots more. Employment Hour 30 is on the way. Stick around.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
And welcome back, Employment Hour in 30. This is the part of the show where we let you go through a tool, a website that over 500,000 people have had the pleasure of having their eyes opened up and their smiles put back in their face, or maybe not, depending on what they got as far as severance is concerned. But either way, you're going to get your learn on for this one. It is the Severance Pay Calculator. Give us some details.
So the severancepaycalculator.com website to give you good news if you haven't yet signed your severance package, or pretty bad news if you've already signed it and that ship has sailed. But let's talk about that. Severancepaycalculator.com. The place to go to if you lost your job, if you're staring at that severance letter and you want to know, is that letter appropriate? Are they offering me the right amount? You don't have to wonder anymore. Once you go to severancepaycalculator.com, in a few seconds you can find out exactly if it's good, if it's bad, how much you're owed, and what the difference is. So once you go to severancepaycalculator.com, you'll answer 3 questions about your age, your position, and the length of your employment, and then you are done. You're going to find out exactly what you're owed. It's free. It's anonymous. There's no strings attached. It's easy to use. I've made it so simple that really there's no excuse for someone not to use it. So go to severancepaycalculator.com right now. Check it out. Even if you haven't lost your job, even if you're curious or worried about losing your job, the very first place you go to.
You know what? We'll give it a shot. I'll give you a scenario that was brought forth by an email we had a short time ago. Basically summarizes. Bryan was a senior project manager earning $120,000 in salary. 2 years into his job, he was unexpectedly fired. He was offered a 1-month severance package. However, because he failed to respond by the 3-day deadline, his former employer told him that the offer had expired.
Well, the best thing that Bryan did is not accept within that deadline. And let's talk briefly about deadlines. These deadlines are meaningless. Your legal rights don't expire Friday at 5, Tuesday at 2, whatever that deadline is on that piece of paper. Your legal rights are what they are, and you have 2 years to pursue them. So Bryan did the right thing by not accepting, because guess what? He's owed a lot more than a month's pay. But we're talking about severancepaycalculator.com. So let's plug his information in so everyone can see how it's actually used and how it works. So Bryan was a senior manager. He worked there for 2 years. He's 42 years old, making $120,000, and he was offered 1 month's pay. Well, let's plug it in severancepaycalculator.com. It works its magic and tells us that he's actually owed 4 to 6 months' pay, and that's a difference of somewhere between $30,000 to $50,000. Had he accepted this, he would have lost at least $30,000. So the deadline is meaningless. He's going to get what he's owed, and severancepaycalculator.com works just as easy. It took me 10 seconds to tell you what the result is. It would take you 10 seconds to do it yourself in your situation, so check it out.
And if you're an employer looking to do the same thing, let go of an employee, you want to know exactly what your obligations are, there's an employer mode on there as well.
There's an employer mode there, and it helps you understand what you owe your employees, and it gives you some additional tips in terms of how to make sure that you don't breach your legal obligations.
Everything else about the show, employmenthourtv.ca is where to go, including where to find the radio show, or at least listen to the radio show sometime during the week, which has been a 7-year run so far. Going strong. A lot of phone calls on the show we get, and we play them back on this show as well. We'll get to one right now.
My mother, she was hired on as a full-time employee and was originally working about 7.5 hours a day. And recently, her employer decided to reduce her hours to 4 hours a day, and without any notice. And then when we went to the HR department, they said, oh, well, we lost some business, so we had to make cuts.
Yeah, and I remember this call as well, and it's a very common call that we get. So first of all, let's assume that the company is telling the truth, that there's legitimate business reasons as to why they had to cut hours from 7.5 hours a day to 4 hours a day. Let's assume that's right. The fact that that's right, the fact that there's a legitimate business reason does not make it legal. It does not. The company still does not have a right to reduce hours, even if they have a good reason, even if they have a business reason to do it. Because a significant change to the terms of employment like that is a constructive dismissal. It's a termination. A company cannot do that. 7.5 to 4 hours, that's almost a 50% reduction in her hours and her compensation. That's not even close to being legal. So what can this person's mother do? Well, she can accept it. And by the way, if she were to accept it, she'd give the company the right to do it again. Right? Yeah. Bad idea. Or she could treat that as a constructive dismissal, leave now with severance. And the nice thing about doing that, John, is that her severance is going to be calculated on the basis of the 7.5 hours. Her current hours before the reduction. So that's what she can do. That's illegal to do what they've done. And even if it was a smaller reduction, it would still be illegal. Again, check it out, severancepaycalculator.com for any details on your particular job and find out what you'd be in store for if it ever came down the pike. Coming up here, we'll get this, should social media blunder trigger termination, that enforce resignation for an honest mistake? That's all on the way. 1-855-821-5900. Again, employmenthourtv.ca. More Employment Hour 30 is on the way.
You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Hour 30 continues for this week. We go to employmenthourtv.ca. That is your resource to find stuff about the show and find out where you can catch the radio show that we do weekly, have been doing for years and years and years. Get a ton of phone calls on the show. We've played back a couple so far this half hour. We'll get to another one. I know you want to talk about that as well, Lior.
Last week, I was let go from my employment after 25 years for just cause, and legally, I'm just asking you what I'm entitled to. It said in the letter, for just cause, misconduct, willful misconduct.
So what do you think?
Well, obviously, we would need more information. I'd need to know, what did he actually do? How bad a mistake was it? Is it one of those things that he could have easily avoided? Was he completely negligent? So there's a lot of questions here. But, the key here, as far as I'm concerned, is he talked about an honest mistake. And is it really an honest mistake? Is it a big deal? It's very difficult to terminate someone for cause. So let's start with that. It's very, very difficult. For him to be terminated for cause, he would have had to do something terrible, something horrible, something so bad that it would be inconceivable to continue employing him. And in my experience, I don't know anything specific about this situation, but in my experience, the vast majority of people that are let go supposedly for cause, there really isn't cause. That's a wrongful dismissal. Whatever they did, even if they've done something wrong, does not quite rise to the level of cause. So chances are, just statistically speaking, that he is in fact wrongfully dismissed, that in fact whatever he did is not bad enough. If that is the case, then he is owed severance. He's owed full severance. The fact that he did something wrong does not mean he gets a discount on severance. He gets the full amount. So how much is that? Well, again, we talked in the previous segment about the severancepaycalculator.com website. Let's plug his information in. Let's see how much he would actually be owed. So he's a supervisor, 25 years of experience or of service. I picked an age, let's say he's in his early 60s, etc. And obviously he was offered no severance because the company said it had cause. So severancepaycalculator.com does its magic and shows that he's owed, in fact, 24 months of pay. 2 years. So the difference is between 0 and 2 years pay. That's a huge difference. And this is a common situation. I get calls like that all the time, or variations on this call, where people are supposedly let go for cause. There really isn't cause, and they realize, holy cow, I'm owed a year's pay, 2 years pay. It's a big deal. So that's how the severancepaycalculator.com works. And remember, it's very difficult to terminate an employee for cause.
Another resource for you to ask some questions anytime, whether the show is on or not here on the TV, is terminationquestions.com. Drop-down menu. There's a fairly high probability that your question has been asked. If not, leave it there. Lior, a member of his team, will answer it and get back to you. More knowledge, always a resource for knowledge, terminationquestions.com. I'll get to one, Lior, from that website. It says, I made an honest mistake on the job, which resulted in the company losing a new client. Instead of firing me, my employer let me resign in order to keep my record clean. What was or is the best option?
Yeah, and this is a situation we refer to as a forced resignation. We've talked about this before on the show. In a situation where your employer is telling you, you have to resign or else, and then you resign, that is not a resignation. That's actually a termination, because you're not leaving because you wanted to. You're leaving because your employer essentially put a gun to your head. That's not a resignation. That's a termination. Now, he talks about the fact that he wanted to keep his record clean. That's a misconception. There's no record. There's no big depository or big warehouse where they keep people, a vault where people can go and say, oh, let's see why John was let go. It doesn't work that way. So it's simply a question of whether or not you get severance or not. I would much rather you be let go than resign, because then it's much easier to get severance. If your employer tells you, hey, resign or else, the answer should be or else. I am not going to resign. If you want to let me go, let me go. The company's going to owe you severance. Now, will they owe him severance in this situation? It really does depend on what he did. Here's that term, honest mistake again.
Seems like one.
If he made one honest mistake, and it wasn't a situation where he completely did something deliberate or was trying to hurt the company, it's probably not going to be just cause, not even close. So he's going to be owed his full severance. So even if in a situation where you resign, I want you to call me right away, not a year later, not even a month later. If you've been put in a situation where you felt you had to resign, let's speak right away. Let's deal with it right away. The sooner we get to it, the sooner we can deal with it, the more credible it is that you didn't just resign because you wanted to. You resigned because someone told you that you had to. So don't ever let that happen to you. And just from the sounds of it, this person that left the question on our website is owed full severance.
You know, it's funny. You've often mentioned, as we were talking about, being let go for cause. It really is what they call the death penalty of the employment relationship, and it's not an easy threshold to get to, right?
It isn't, and a lot of employees that are let go for cause don't pursue it because they say, you know what, I did do something wrong. I don't have clean hands.
I dropped that skid, or
I did
something.
I made a mistake. It cost the company money. My bad. So clearly that's cause. It's not cause. The fact that you did something wrong does not mean it's cause. It would have to be very bad. You would have to have multiple incidents. You would have to be warned, potentially even suspended, before the company can consider cause. In most cases, John, the company jumps the gun way before it should.
Before you do anything, make that phone call 1-855-821-5900. There is severancepaycalculator.com. Remember, over 500,000 people have trusted and used the Severance Pay Calculator. There's no charge. It's anonymous. There's an employer mode, and there's a place to contact Lior and his team when you're done that as well. Emails help@employmentlawyer.ca. And again, the radio show, which we'll be doing, it'll be a decade soon. Eventually, we're going to get to a decade. EmploymentHourTV.ca is the place to find that radio show. Till next time, Employment Hour in 30. Thank you for joining us.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.